Okay. Okay, Roger, I still don't have a full screen here, but I'm trying to see if everyone's here. Okay. Mr. Secretary, are we waiting for Commissioner Montemayor to join us?
Yes.
Okay.
Yeah.
Give him another minute to, there we go. All right. Okay. We have everyone on video at this time. There we go. All right, at this time, I'd like to call the January 13th, 2021 meeting of the Rent Stabilization Commission for the City of West Hollywood to order. Commissioner Ayers, would you be so kind as to lead us in the Pledge of Allegiance, please?
I pledge allegiance to the flag of the United
the
States
United States of America,
and
and to the republic
for which it
for which it
stands,
stands,
one
one
nation,
nation,
under God,
under God,
indivisible,
indivisible, with liberty and justice for all.
all.
Thank you. Mr. Secretary, may we have a roll call, please?
Commissioner Ayers,
Here,
Commissioner Kirpies,
Here.
Commissioner Maggio,
Here,
Commissioner Montemayor,
Here.
Commissioner Topshin,
Here.
and with Chair Martz absent tonight, Acting Chair Copeland.
Here. So noting the absence of Chair Martz, we do have a quorum. The next item is the approval of the agenda. Are there any proposed changes to the agenda
Motion
from
to approve.
staff or commissioners? No, okay. We have a second?
second,
All right, we have a motion and a second to approve. May we have a roll call vote, please?
Commissioner Ayers. I might have missed that. Sorry, Commissioner Ayers. Excuse me.
aye.
Commissioner Kirpies,
Aye.
Commissioner Maggio,
aye,
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Chair Copeland.
Aye, and the approval of the minutes of the agenda passes. Next up is the approval of the minutes. Has everyone had a chance to read the minutes from the last meeting, December the 9th, 2021 meeting?
question, please.
Okay,
Under
Commissioner
public comments, Robert Oliver, was he not a commissioner representing one of the commissions? Was he not the liaison? Because it just says commented on the work on behalf of the commission.
I believe he mentioned he was calling in as a tenant or a resident. Sorry.
He's a resident. All right, thank you very much for the clarification.
are there any other questions with regard to the minutes? Okay, if not, do we have a motion to approve?
I'll make a motion to approve.
I'll second.
We have a motion by Commissioner Maggio and a second by Commissioner Ayers to approve. May we have a roll call vote, please, Mr. Secretary?
Commissioner Ayers,
Aye.
Commissioner Kirpies,
Aye.
Commissioner Maggio,
Aye,
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Chair Copeland.
Aye. And the motion passes. Approval of the minutes. Next item up is the public comment period. Do we have any speakers of the from the public this evening, Mr. Secretary?
Not at this time.
Not at this time. Okay. Then we will move on to the manager's report. Mr. Hollop is ready with that, please. I'm sorry, I couldn't hear you.
I'll get used to this after 2 years.
Thank you.
Good evening, Chair, Commissioners, Jonathan Hollop. I'm the manager of the Rent Stabilization Division. Tonight, we're going to be hearing, you're going to be hearing one appeal. There's also an item that we continued from last month related to Rent Stabilization Ordinance and Regulation amendments. At the meeting at the end of the month, currently there's 2 appeals listed. Actually, one of those is going to come off calendar. Not sure if it's going to come back on, but if it does, it will be at a later date. And also CES will be presenting on tenant assistance services that they offer at that meeting. On the 10th, there's currently 2 appeals scheduled. February 24th, there's 1 appeal. It's actually an increase case, which I don't think the commission has heard in quite some time. So it'll be something a little different. Actually, it's not on the agenda yet, but I anticipate that the Social Services Division will be appearing in front of the commission to ask for input from the commission on its social service priorities. That'll be on the 24th. On March 10th is currently 1 appeal scheduled. It's possible to be another one coming then, and I'm sure more coming down the pike. As I constantly say at these meetings, there's still funding available through the California Rent Relief Program To date, I believe it's over $17 million has been distributed to over 1,100 households in the city, or approximately 1,100 households in the city. So the program is moving along quite nicely. There has been another round of applications that are being accepted. So if anyone needs to get rent relief, I strongly encourage them to visit housingiskey.com, and applications are still open. And as far as I know, that is still going on. And I think that is all that I have right now. I'll be back for more with the item that I mentioned earlier. And if there are any questions, I'd be happy to answer them.
Okay. Any questions for the manager regarding the manager's report? Not at this time. Are there any commissioner comments at this time?
Yes.
Commissioner Kirby, yes.
Yes, I just want to remind everybody that on the 26th of January, 26th and 27th, actually throughout Los Angeles County, they'll be doing the annual homeless count. I'm not sure if they're still accepting volunteers or not, but you can go to the LAHSA website at lahsa.org if you would like to volunteer that evening or or one of the mornings. There's throughout LA County, they have a couple they have locations for Thursday night and Wednesday night, and then also if you're willing to go to like Palisades and Malibu, that area, I believe it's like Thursday morning, early in the morning to do counts.
Okay, thank you, Commissioner Kirby. Are there any other commissioner comments at this time? All right. Are there any comments from members of the public at this time before we get into our appeal portion?
We have
Mr.
no
Secretary.
public speakers.
Okay, great. Okay, we're at the appeals portion of our agenda. We have an appeal before the commission this evening. It is D-4603 7553 Norton Avenue, number 8. Do we have a representative of the tenant
Yes, that's me.
and a representative of the landlord present?
Yes, that's me.
Okay, thank you. I'll give some instructions for the appeal first. First, we'll hear a staff report from our staff's legal counsel. And then the appellant will speak first. In this case, that would be the tenant. You have 5 minutes to discuss your appeal, and you have the option of dividing your 5 minutes into 2 segments. So if you would like to use part of your 5 minutes to state your case and then the remainder to state the rebuttal, you may do so. Just state how you would like to divide your time when it's your turn. And the respondent, which is the landlord in this case, will speak second, and you'll have 1 5-minute segment to state your case on the appeal subject. When it's time for you to speak, you'll unmute yourself and then state your name and city of residence for the record. And the appellant will state how they'd like to divide their time at all, and then proceed with your comments. Since the speaking time is limited, it's very important to keep the following things in mind. Keep on topic. The only information you share should be about the appeal topic. New evidence cannot be considered by the commission. You may only discuss issues that were raised at the hearing or evidence submitted to the hearing examiner. At this time, you can make sure that you're on mute, and we will let you know when it's time for you to start. If we can have the staff report by legal counsel now, Mr. Natalizio.
I'm sorry, I have one question. Is that okay?
Is that a question on the process?
Yes.
Okay.
So I submitted a statement previously. So do I still state my case, like re-say all that?
Your statement is part of the record. You can state whatever part of the hearing evidence that you presented or information that's in your statement that you would like to present during your 5 minutes, as long as it's not new evidence. Is that correct, Mr. Natalizio? Okay, thank you.
That's correct, Chair.
Thank
Okay.
you.
All right, if we're ready for the staff report.
Good evening, Chair and Commissioners. Everyone, my name is John Natalizio. I'm the legal counsel to the Rent Stabilization Commission for the city. This appeal was filed by the tenant Eric Seaver in response to the hearing examiner's decision denying a rent reduction application regarding the elimination of a second parking space. The hearing examiner found that the lease only permitted one parking space, and any additional parking spots utilized by tenant were the result of informal private agreements between the tenants and was not a housing service that was actually provided or agreed to by the landlord. And based upon this, the hearing examiner determined that tenant did not meet his burden to prove that the additional parking space he utilized was a housing service. Tenant filed his appeal of the decision. The appeal claims that the decision is not reasonably supported by the findings made or evidence in the hearing record. And the appeal submitted argues that tenant has been using the second parking spot for 20 years and that he has never seen a copy of the lease until 2021. Staff has reviewed the appeal record and recommends affirming the hearing examiner's decision. As discussed in the staff report, the fundamental question the hearing examiner had to determine was whether, one, the landlord actually provided a second parking space to tenant, or two, agreed to a second parking space with the tenant. And regarding that latter issue, the hearing examiner found that the testimony and evidence showed that the landlord did not agree to a second parking space, and that there was no evidence submitted in the record that showed either the previous or current landlord agreed to give the unit a second parking spot. And regarding the former issue, again, there was no evidence submitted in the record that showed that either the previous or current landlord agreed to give the unit a second parking spot. The lease specifically sets forth that the unit is only entitled to one parking spot, and the addendum is silent on parking. The lease also provides that the use or entering any space or area rented by other tenants without landlord's consent is prohibited, and the lease specifically identifies parking spaces. The fact that there was available and unused parking in the parking lot and that tenant utilized the available parking spots with the consent of other tenants does not automatically impose such agreements onto the landlord. Lastly, the evidence, including tenants' own testimony, submits that the parking arrangements were generally private agreements between the tenants and were not formal agreements involving the landlord. Therefore, based upon the above, staff believes the hearing examiner was correct when he concluded that tenants' use of the additional parking spot, even over a long period of time, does not make it a housing service when there was insufficient evidence to show that the second space was actually provided or agreed to by the landlord. As noted in the staff report, while there could be argument the housing examiner could have ruled another way or weighed the evidence differently, the basis for substantial evidence does not allow a reweighing of evidence nor a substitution of judgment. Staff believes a reasonable fact finder could have come to the same conclusion based on the facts and evidence in the record, even if there's contrary evidence. Therefore, based upon the above, staff recommends adopting Resolution RSC 22-605. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure that there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you. Yes, Commissioner Topton, you have a question for Mr. Nally too?
Thank you, Madam Chair. Mr. Natalizio, just a simple question. On page 776 of the packet, there is a copy of the email and what appears to be is the first page of the stipulation for judgment for the unlawful detainer case that references the addendum, lease addendum. That's the only document we have that was submitted to the hearing that will mention the addendum.
Yeah, my understanding of the record is that this addendum that was submitted is the only addendum to the original lease that identifies Mr. Sieber.
Which my confusion was that referencing that, and the tenant is in the email says this is the here it is. This is the addendum. So this is not the addendum. This is the stipulation for judgment where it is mentioned there is an addendum. So I just want to be correct, precise, that this is not the addendum. This is just the mentioning of that there is a lease addendum to 4/15/97 lease. That's how I read it, but I don't believe this represents the actual part of the addendum because this is a stipulation for judgment.
My understanding is that this is the lease addendum, but if either Mr. Seaver or the landlord wants to make a statement otherwise, they're free to do so. This was submitted to the hearing examiner, so it can be discussed. But at least my understanding was that this was addendum, but I guess if it's reflecting what the addendum says in terms of effectiveness of evidence, I think it still shows the same thing. But you could ask either Mr. Seaver or the landlord.
Yeah, I will ask the parties. And the next question is just to clarify for me, when you stated in the report the tenant first become aware of the lease agreement in 2021, that's the reference to the 1997 lease agreement, right?
That's my understanding, correct.
Okay, all right, thank you.
Thank you. Are there any other commissioner questions for legal counsel at this time? Okay, and we'll begin with the tenant. Mr. Siebert, if you could please first identify yourself and your city of residence for the record. And then if you would like to divide your time for a statement and then rebuttal, like 2 minutes and 3 minutes or vice versa, however you'd like to divide that, please let us know that at that time. And then you may begin.
Eric Seaver, West Hollywood, California. I would like to divide my time.
Okay, how would you like to divide that? How much for your statement and how much for your rebuttal out of the 5 minutes?
3 minutes for a statement, 2 for rebuttal.
Okay, thank you. Okay, you may begin.
So from day one of me moving into this apartment, I was told by the previous landlord and my roommates that we had 2 parking spaces. We never saw a lease, not once. My landlord, then the building was taken over by the Heifetzes, and they fully knew that I was using 2 parking spaces. Every time they would come to the building to fix something, they would park in whoever parking spaces weren't used. So I would constantly, if they were parking in my spaces, say, can you please not park in my space? We need to park in our own spaces. And so she was aware for sure that I was using 2 spaces. I constantly, repeatedly asked for a copy of this lease so that I could solidify certain things, namely the parking situation, because no one ever had anything in writing. And we were told verbally these things. I was told repeatedly there was no lease or that I was not on the lease. So then I went to the city. I asked them, what do I do in this circumstance? They said, if you don't have a lease, if you're not on a lease, you're not governed by specific things like parking. So if you park in a space over a prolonged period of time, it becomes yours. That is literally what everybody from the city ever told me. So that's what I was doing. I was following guidance. And so I believe that these parking spaces are mine. I've been parking there for over 18 years. She never said one thing about it. She could have resolved the situation and gotten to the bottom of this when I initially asked for the lease the first time, which was about 18 years ago. So I think that's my statement.
Mr. Secretary, how much time does Mr. Seaver have left?
He has 3 minutes left.
Okay, so when you return, you may have up to 3 minutes for your rebuttal.
Sure.
At this time, if we would like to have Ms. Heifetz speak, please. And you have, if you could state your name and your city of residence for the record, and then you have 5 minutes to.
My name is Rona Heifetz.
Chair, sorry, excuse
Sorry,
me.
yeah, go ahead.
I think there were some questions that the commission wanted to ask of Mr. Seaver before the landlord's comments.
Before both comment, not at the end? Okay, I'm sorry, go ahead.
Hi, do I have the option also of splitting my time?
Hold on just a minute, please.
Commissioner, I guess Commissioner Kirkus raised his hand first. If you want to go first.
Go for it, Commissioner. Or I'll go.
Okay.
Okay.
Okay, thank you.
Mr. Kirby's.
Okay. Hello, Mr. Seaver.
Hi.
I had a question about, you mentioned when you moved in, you parked in that spot since the very beginning. In the testimony, or at least the record that shows here that you moved in 2000, or if I'm reading it correctly, 2000, and then started parking there in 2003. Is that correct?
Yes, I'm sorry. No,
That's fine. That wasn't really, yeah, my real question is, so what did you do from 2000 to 2003? Did you not park there, or did you not have a vehicle? Was it not relevant?
I didn't have a vehicle.
Okay. And then my other question was, again, when I say you stated, it's not verbatim, so I don't mean you put words in your mouth, but in the record, it states that when the two other roommates moved out, your first two roommates were there, you moved in, you began in 2003, you began parking there. The other roommates moved out, I believe, in 2005, and then a new roommate moved in, and it says the new roommate then used the extra parking space previously used by the former roommates. Is that accurate?
Well, my two roommates moved out in 2003.
Okay.
And so I was without a car from 2000 to 2003. And then I started parking in the space, and then they moved out. I got another roommate who then was using the second spot.
The original spot that your two roommates had been using, right?
Yes. Yes.
Thank you.
Commissioner Topchin, you had a question for Lieutenant?
Yes, thank you, Madam Chair. So the question would be, the question that I asked the legal counsel, Mr. Seaver, that page that you submitted along with your email, which is the page from the stipulation for judgment for the unlawful detainer, that referenced the addendum to lease. So do you believe that's the actual addendum to lease, or there is another actual document addendum to lease that exists?
I believe, and I was under the impression that there was another completely different addendum to the lease that we never ever saw.
But you remember signing something?
I don't
Addendum
remember. No, I don't remember signing.
So you don't remember signing it?
No.
So, okay, but you remember but you know there is a document, addendum to lease.
I do remember that because in the statement that I sent just recently, I had wanted to confirm with the previous the landlord's mother to solidify the parking stuff. And so that's why.
All right, but you are certain that there is the second parking space is in that document?
I'm pretty certain.
Okay. All right, thank you. So the question about, but do you understand that the 1997 lease agreement is for those two original tenants, the terms that were set for them, not for you? When you moved in, the tenants who you moved in and they were your roommates, you actually became their roommate. So that rental agreement was set the terms for their tenancy.
Yes.
That part is clear.
Yes.
You don't dispute it. Okay.
No.
Oh, all right. Thank you. Nothing further, Madam Chair, this time.
Are there any other commissioner questions at this time for Mr. Seaver? The landlord has asked about the division of time. The process is normally that the appellant may divide their time and the respondent has their 5 minutes in entirety. Is that correct, Mr. Natalicio? I'm going to make sure that I'm correct on that process.
Yes, Chair.
Okay, thank you. I'm sorry, we will move on to the landlord's part right now. If you would like to state your name and your city of residence for the record, please, and then you may have 5 minutes.
Hi,
Thank you.
my name is Rona Heifetz. I live in Beverly Hills. I always told him, and I showed him a copy of the original lease, which is what my lawyer said that I should show. I'm not trying to hide an addendum. I took over a building that was my parents'. I tried to figure out the parking situation. And around in that building, everyone always said, I have 2 spots, I have 2 spots, I have 2 spots, I have 2 spots. There's not enough for everybody to have 2 spots. Eric told me he was using one of the spots from number 6, where number 6 only has 1 spot. So when he says that he's been using the same spot for 17 years, that's not true. Even here it says, according to the tenants, whenever there was a parking issue, the tenants generally dealt with it themselves. Everybody, it was like a free-for-all and everyone parked wherever they wanted. So when I wanted to give a new spot to a new tenant, I needed to sit down with everyone and say, which one is your spot? Because I want to mark them so that there's no confusion anywhere. So when he sits there and tells me that they've been in the same spot for years and years and years, it's impossible because everybody was moving around. Even one of the tenants marked his number on the pavement because there's only 1 number on the pavement so that nobody would park there. So my confusion here is on the lease, it says 1 spot. He's always had 1 spot. He was always told that he has 1 spot and there's nothing that changed. Is there anything else I need to add?
Well,
And I've told him for a long time, not just now, not from just 2000, from when I took over the building in 2015, that he only had 1 spot. And the addendum had nothing to do with the parking.
And you've called the city.
Yeah, I've been dealing with this for a while. It's not something that just came over now. This has been going on since I took over the building 6 years ago. I really don't know what else to say. I mean, there's no copy that I went to the city. I said, I just want to make sure that I dot all my, cross my T's and dot my I's here. Do you have anything that shows differently? And they said, no. So, I mean, I don't know what else to say.
Okay.
He was assigned 1 spot.
Okay. Does that complete your testimony then this time? Okay, thank you. Commissioners, do we have any questions for the landlord at this time? Commissioner Topchin.
Thank you, Madam Chair. Ms. Heifetz, so the same question, although you mentioned the addendum. So the addendum, that addendum doesn't exist? Or it does?
Years ago, it had nothing to do with parking.
There was 1 addendum that they showed me when we had the last case. I'm looking for a piece of paper that just had his name on the addendum to the lease, that he was put on the lease.
You mean the tenant, Mr. Seaver?
Yeah, Mr. Seaver, the existing lease.
His name on the addendum, and that addendum, as you stated, has nothing to do with the parking issue?
No, it has nothing to do with the parking issue.
And again, I don't know if I can ask that question or not, but I'm going to do it. Unless the legal counsel says no. What's the reason? Why didn't you present it at the hearing so then you would clarify there is nothing about the parking on that addendum?
It was brought up at the hearing. They
Oh, it
showed
wasn't-
it to me. They're the ones, Eric submitted it.
No, I'm not talking about that page from the unlawful detainer document that is a stipulation for judgment. That's not the addendum. That referenced the addendum to the lease from April 15, 1997, saying that there is a addendum. So I wonder if there is an addendum to the lease, if there is a document.
I've gone through every single piece of paper and every piece of paper on the file, and I didn't have one. So there was something presented at the last hearing that was an addendum with his name on it that put him on the lease.
When was this unlawful detainer case? You were the owner at the time?
No,
You were not the owner at the time. Okay. All right, thank you.
All right.
Nothing further, Madam Chair, this time.
Thank you, Commissioner Topchin. Are there any other questions at this time from commissioners? Okay, yes, Commissioner Kirkpatrick.
Yes, I just have one, I'm sorry, Miss Heifetz. Did you ever at any time have to enforce the parking rules, or whether this tenant or another tenant, did you ever have towed, or did you ever fine, whatever enforcement might exist?
no.
Thank you.
Thank you, Commissioner Kirkpatrick. Are there any other commissioner questions at this time for the landlord? Okay, I do have a couple of quick questions, if that's okay. The issue with the parking, is this something that you have told all tenants that they cannot use another tenant's extra space, or they're not allowed to share spaces, or so this
Now.
is something that you've done across the board, not just with this individual tenant, but this is a new rule, so forth, that you're trying to enforce?
Absolutely.
And at any time now or before that you're aware of, has there been any separate charge or additional charge for parking spaces or extra parking spaces from management to tenants?
I heard that in the past, the old landlord did charge people extra money to have a space.
Okay, that's not being done at this time.
No.
Okay, if there are no further questions for the landlord from commissioners, then at this time, the tenant and Mr. Secretary, if I'm correct, the tenant has 3 minutes for his rebuttal.
That's correct.
Okay, thank you. You may begin, Mr. Siebert.
The lease does not identify specific parking spaces, as Rona just said. The parking space situation has always been convoluted, always been very confusing. Nobody ever knows where to park down there. It's only recently, within the last 2 years, that the numbers were painted down there. And the numbers, most of the numbers are worn off. So nobody really knows where to go or where to park. Rona has never communicated ever to anyone I know living in the building, including me, the rules of the parking situation. She doesn't want to deal with it, in my opinion. So we've heard radio silence about any of this. At least I have heard radio silence. I park in different spaces because it was never enforced that I actually have 2 spaces. So I had to park wherever a space was open because people were parking in my space, including Rona when she comes to visit the building. So that's why I park in different spaces. I have 2 parking spaces for 18 years, but I wasn't allowed to park in the second one for an ongoing period of time because of this convoluted situation. So that's that.
Can I add something, or is it?
Chair, you're muted.
I'm sorry. Mr. Seaver, you still have how long, Mr. Secretary?
1 minute and 27 seconds.
Is there anything that you'd like to add?
I guess regarding this addendum, at the time of the hearing, I communicated directly with Eva, Rona's mother. I asked her, please, can we confirm and solidify this parking thing? Because I had been parking in 2 spaces up till then, right? And so I asked her if she would solidify it. She said, we'll think about it. Well, I'll look at it. And I kept asking. I would ask anytime I could. And I never, ever got an answer other than there is no lease. So that's really all I have to say.
Okay, before we begin commission deliberation, is there anything else from legal counsel or commissioners? Commissioner Topchin?
Madam Chair, is this time? Can I ask a question?
Yes.
Mr. Seaver, thank you. Mr. Seaver, you said during all these years, since 2003, since you started parking, was there any communication, any whatsoever, any text, email, anything, any notice posted on the premises saying, hey, don't park anywhere? Any sort of attempt to regulate this parking issue by the property owner?
No.
At least you don't know if there was any. You didn't receive anything. That's
Well,
what you
I know that I never saw anything posted in the front where usually letters are posted about building matters, and nothing was texted to me or emailed to me or communicated by phone ever.
Okay, thank you.
Other commissioner questions at this time?
Can I add something? Because I have emails and texts. I've been trying to make the garage not chaotic and to put numbers down. So I have a lot. He's been asking me about the parking situation for a long time. And I said, you have one space. I've been saying it for a long time. This is not something new. Look at look at your writing of the email communication
Okay,
and the texts.
excuse me, this time. Commissioner Kerpes, did you have a question or you just?
I just had questions for legal counsel when you're ready, Chair.
Yes, go ahead, please.
Mr. Natalizio, I assume you're still there. Yeah. I have just a couple questions for you. This is slightly changed in the testimony that was given this evening, but if we look at the record, it basically has Mr. Sears.
Seaver.
Seaver, sorry about that, Mr. Seaver parking in the same spot from 2003 to present, even after his roommate moved in, a new roommate moved in and used like what they referred to as the extra or the second parking spot. My question, I guess, is if a parking spot was removed, that second spot, does Mr. Seaver have, I guess, standing in this situation? Because he is the one on the lease that has the parking spot. I don't know if his roommate was on the lease, or is that all irrelevant?
I think, well, I think it's all irrelevant. I think that there's a standing argument that would have to have been brought at the hearing. But I mean, to opine, I think he has standing in the sense that the addendum brought him onto the lease, and the landlord isn't claiming that, you know, he's not a tenant or he's not entitled to the provisions of the lease. So I think we can look at the lease as if Mr. Seaver was like an original tenant on it.
Okay. Yeah, well, my question wasn't about him being the original tenant. He would be the original tenant. It'd be the extra spot, but I think you answered my question. If it's irrelevant, then I won't pursue it. The other question I had was, I guess this question is for Mr. Seaver, if that's all right, Chair. You did mention this evening that you would park in different spots. Are you prohibited from parking in other spots now? What's the situation currently when you get home in the evening and you drive in and the place where you thought you were going to park on your ride home isn't available? Does that happen, and where do you park?
Well, let me clarify. What I meant by that was that the second space, they always have to find an alternate space.
So I guess I change my question then. Your roommate, where do they have to park if they're driving home and they find that they get to the parking garage and the second spot that you have, they can't park there? What's the standard practice that they do?
They will always park on the street. Like I've told them they can't park in somebody else's space because, you know, we don't even know.
You answered my question. Thank you. I appreciate it.
Okay, thanks.
That's all I have, Chair.
Thank you. Any further questions from commissioners at this time? I do have one more question for the landlord. So was there, how were tenants notified that this parking situation, there would be no more sharing or giving of parking spaces, or this was something that was done recently? This was not something that was sent to tenants, you're violating the rule by parking here. This wasn't an ongoing thing. This is something recent, if I'm
Well, it's been
understanding
going
this
on
correctly?
for, since I took over the building. And then most recently it came because I guess somebody had a 3-bedroom, it had 2 parking spots and only one of them had a car. So the second spot people were just using. And then I had new tenants that were moving in and they needed the 2 spots. And when I went down to the garage, I couldn't give them the 2 spots because somebody else was there. So I sat down with every tenant and every unit and said, everybody gets a spot. Please show me, I know where some people have parked for a long time. And it was very confusing me because a lot of people were taking other people's spots. So the whole thing was that I wanted to put down numbers so I can make it less confusing for everybody. When
And
I
you
have a
took
new tenant that comes in and out, I want to be able to say, this is your spot for number 1, number 2, number 3, number 4. And then this whole thing again happened with Eric saying, you have 1 spot. And
So
that's
you
why
took-
the second spot had to keep on changing because he had 1 spot.
Okay, you said you took over in 2015,
Correct.
and this is something that's just happened in the last year or so, that there's been a definite, okay, this is where everyone is parking, whatever you
Happened-
signed, and that's it?
Well, it's been going on since I took the building over. But like I said, there was a couple of times where like a 3-bedroom had 2 spots and they were only using 1. So
Mhm.
other people would park in the other person's spot, but it wasn't their spot to park in. They just saw empty spot and they used it.
And how were tenants notified about?
I
The
spoke to
enforcement of
them.
this?
I have a pretty good relationship with most people.
Spoke with them personally?
Mhm.
Okay. I have one final question for Mr. Seaver, if that's all right. Was there at any time over the years that you received anything from management before this saying it's a violation of your lease to park in, any other spot, and tenants are not allowed to park in the other spot? This is very recent?
Well, I still have not seen any communication about parking. I never have recently.
Nothing in
I
writing?
don't know what she's talking about.
You mean nothing in writing other than the verbal?
Nothing in writing, nothing verbally, nothing through text. I haven't seen anything.
Okay,
So,
thank you.
yeah.
Anyone else? Questions before we go into Commissioner deliberation?
But there is evidence from the last trial that there was text and emails about this. About him getting the lease to know how many parking spots he has. It was submitted.
You're muted, Madam Chair.
I'm sorry, again, hit the wrong button. At this time, we're going to go into Commissioner deliberation. So if you would like to go back into the waiting room, and if you'd like to listen to the rest of the meeting, you may do so. At this time, we'll have Commissioner deliberation, and then we will have a motion. So,
May I begin,
This
Madam
time?
Chair?
yes,
All right. Thank you, Madam Chair. I read this over and over again, and I'm a little bit confused. And I would say I disagree with the examiner's decision. I'm going to explain the reason why. The tenant moved in January 2000, and in 2003 he started using the garage to park his car. So the 2 roommates that were original tenants of that original rental agreement, they moved out in 2005. I think that's the chronology. So the relevance of that 1997 rental agreement after 2005 is really zero to me. in relation to the tenant, Mr. Sever. Sorry if I mispronounced your last name. So I believe the relevance of that 1997 agreement is irrelevant. We don't have any addendum to lease, any document that would show something that would produced by the landlord that would show that this rental agreement with all the terms and conditions that includes parking will transfer to the existing tenant of record. There's nothing there. So we always say, and I just want to remind the commission, we always say that to establish a housing service under the rent stabilization ordinance in West Hollywood, the service doesn't have to be in writing. So the ordinance doesn't require a service to be in writing in any form. It could be just verbally given, or it could be the landlord didn't do anything and the tenant used, which implies that the landlord didn't want to take away that service that the tenant was using. So that will become a part of the rent that the tenant pays. So that's how the housing services are established in West Hollywood, pursuant to the rent stabilization ordinance. So that's why I kind of disagree with the examiner's decision that was solely based on the absence of the documentation that would show that the tenant had the second parking. My position is this. Until these two roommates were there, which is I don't like to call them the roommates, I call them original tenants of that record. Until 2005, that rental agreement was important, that's relevant, okay, to the establishment of whether one parking was included or two parking spaces. When these people moved out, so he continued to pay rent. So he became he established his tenancy, and that rental agreement is no longer relevant. So he established his tenancy, he is an authorized occupant, whatever rent he pays, and whatever services he's using. He never had any rental agreement, and the municipal code doesn't require to have a rental agreement, doesn't require any written document in order to establish tenancy relation, landlord-tenant relationship, or establish a housing service. So the tenant pays rent, uses both parking spaces, that becomes a housing service. So that is the rent stabilization ordinance. So now in 2015, when Ms. Heifetz takes over the property, that's already 10 years of the tenant using the second parking space. All right. The previous landlord chose not to do anything, elected not to enforce the one parking space rule. And by doing nothing, the previous landlord basically established a second parking space for this tenant. So therefore, when in 2015, Ms. Heifetz took over, and she took over, and I understand with her good intent to manage properly, to regulate the parking issue, so there wouldn't be any problem with the other tenants, with other units, who has how many parkings. I understand it's kind of a messy situation. But the bottom line is, if it's before us, and if we have to apply the RSO would be applied that way. In 2005, the tenant was the tenant of this unit, paid the rent, used two parking spaces, then that is the housing service for which he paid. In 2015, the landlord took over, and now the landlord started giving notices or emails or whatever, asking the questions, why are you parking the second car on the premises? You cannot do it. That is not right. So the landlord cannot do it. In my opinion, the tenant is entitled to rent decrease, and I am in disagreement with the findings of the examiner.
Thank you,
Madam Chair.
Commissioner Topchin. Mr. Natalizio, did you want to weigh in before we have more commissioner comment, or did you have something?
Yeah, the only thing I wanted to weigh in on, just the legal portion of what Commissioner Topchin said. Again, the commission is free to opine and deliberate how they want. But I wanted to let the commission know that it's at least my opinion and advice that the lease, the 1995, I believe it was, lease, it governs the terms of Mr. Seaver's tenancy, that there wasn't some sort of new lease created when Mr. Seaver I guess, began living in the unit. And I understand there might be some confusion or interpretation as it relates to this document that Mr. Seaver submitted. It's on a form of the Superior Court. But it's my opinion that this is the lease addendum that the parties are referencing, and that the terms of this addendum would also govern Mr. Seaver's tenancy, and that the provisions of both the lease and this addendum can be read together and applied to Mr. Seaver. Again, if the commission's free to disagree with that, but I wanted to just give the commission my legal opinion on those issues.
Thank you. Who would like to go next? Commissioner Maggio, do you have your hand up? And then Commissioner Ayers?
I do. I would like to focus really on the conclusion of the law, which is pretty clear in relationship to this particular case. Firstly, no rent adjustment can be granted based solely on hearsay evidence. And that's prefaced by Rent Stabilization Regulation Section 60020. Second, the tenant claims that he has the right to a second parking space on the property. Well, of course, the parking was a housing service actually provided to the tenant. The amount of parking is limited by the lease agreement, which provides tenant with only one parking space. Number three, the tenant use of an additional parking space is a result of an informal agreement among the tenants. And it is significant evidence was provided to show that the additional parking space was a housing service provided only, I repeat, by landlord by agreement between the landlord and the tenant. So I'm going to be inclined to agree with the hearing examiner's conclusion in this case.
All right, thank you, Commissioner Maggio. Commissioner Ayers, you wanted to weigh in?
Yes, I agree with the hearing examiner and the staff in their statement that it is the tenant's responsibility to prove that the landlord either, one, actually provided the unit with a second parking space, or two, agreed to a second parking space for the unit. And I don't think that the tenant was able to satisfy that responsibility in this hearing. And that leaves me, to just weigh the he said, she said, and try to determine what's sensible. And it does sound like from the landlord's evidence that the only tenants receiving 2 parking spaces were the tenants of 3-bedroom apartments, leaving the rest of the tenants with 1 parking space. That makes sense to me, particularly because that's as many parking spaces totally that is available at that spot. So with that, and with a lot of what Commissioner Maggio just said, I am inclined to agree with the hearing examiner's decision and abide by that.
Thank you, Commissioner Ayers. Commissioner Montemayor?
Thank you, Chair. I sympathize actually with both parties here. It's, I think, a classic he said, she said. The fact is there isn't evidence supporting Mr. Seaver's claim. And, I sympathize with the fact that he's had 2 parking spots for a large period of time. It sounds to me, as an aside, that the parking has been mismanaged for years. And clearly the tenants have had to come to their own conclusions on how they've managed it themselves. And it's clear at this point, the landlord is seeking to rectify that. But there's no evidence supporting that Mr. Seaver had 2 parking spots per the lease. And with that being said, I support the hearing examiner's decision. I support my peers on the commission, Mr. Maggio and Ayers, in their conclusions as well.
Thank you, Commissioner Montemura. Commissioner Kerpes?
Yes, thank you, Chair. I believe that I too sympathize with both parties in this case, but I disagree with Commissioner Topchian's analysis that because he was a third tenant, he isn't bound by the lease. He definitely joined the lease at that time, or he joined the residency at that time, and until a new lease comes into play, only then is he governed by a new lease. And that may have happened over the years, but the original lease was one parking spot. And what it sounds like to me is there was a building that each person had 1 parking spot, and the landlord didn't mind if they fought it out among themselves with who they could have their private agreements, whatever. And it sounds like to me that she never, whether it be this landlord or the previous landlord, they never got involved in those disputes, those arrangements, however you want to refer to them. And the tenants worked it out on their own throughout the years. And it sounds like that's the same case today. I don't see where an assigned parking spot was removed from this unit. So I understand that that's challenging, especially since somebody's been using it for so long, but tenancies change, and those agreements and those disputes will change over years with your fellow tenants, neighbors. So I agree with the hearing examiner's decision. There isn't any evidence specifically saying that he has the second unit or the second parking spot. So I would also be voting to affirm the hearing examiner's decision.
Okay, thank you, Commissioner Kerpes. Are there any further comments at this time? Or is there anyone that's, well, if there are no further comments from commissioners.
If I may,
yes,
Madam
please.
Chair.
Yes, go ahead, Commissioner Thompson.
Very quickly. Yeah, you already heard my position. I see the direction that the commission is going to go. I respect that, of course, but I just want to just clarify that stipulation for judgment, which Mr. Natalizio explained and referred to. That stipulation of judgment, the stipulation of judgment is a court document. It has the wording I'm reading right now. It's before my screen. It's on my screen. Lease addendum to 4-15-97 lease for 7553 Norton Avenue, apartment number 8, West Hollywood, California 90046. There is no reference. This is addendum to lease. That there is no reference that the tenant's name is included somehow in this addendum that doesn't exist really. Nobody's seen that addendum. And this document, this page is not an addendum. This is a stipulation for judgment for unlawful detainer page. This cannot be treated as a lease addendum. And the lease agreement was not in the tenant's name. When those 2 original tenants moved out, this tenant's name is not on the lease. This tenant has no relevance to that rental agreement. That is my position, and I just wanted to clarify that. So I believe that this lease agreement from 1997 does not apply to this tenant from 2005, when the tenants from that lease, they moved out. And the last point is that we always said under the rent stabilization ordinance in the city of West Hollywood, no need to sign a lease agreement to become a tenant. I may find an apartment, I may negotiate something verbally, I may pay cash, and I may negotiate any terms and move in and be a tenant and establish a tenancy. So by deciding that there is no lease that would mention something, we're saying basically in West Hollywood, you must have a lease agreement in order to establish tenancy. That is not what the RSO says. So, and the RSO also says it doesn't have to be in writing any service. The service can be verbal, and the ownership may change. The property ownership may switch ownership, the property, but that whatever the service was given, whatever the tenant is using at the time of the ownership, the new ownership, whoever is going to acquire the property, that service remains. Otherwise, we're gonna end up saying, okay, anyone who doesn't have a lease, you don't have a service. You are not a tenant. You can be evicted, or services can be taken away from you. So that is my position, and I'm strictly going by the RSO, what the RSO says. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Kerpies.
Yeah, I don't think there's any disagreement on what the law is and what the ordinance is, but it's still the responsibility of the tenant to prove that that was a service, and that's, I think, where we're disagreeing on. He could have, I mean, the facts may be that he could have made some agreement with the landlord when he moved in, but he hasn't proven that, in my opinion.
And I echo Commissioner Kirby's comments, and I think it's important to drive this point home. I don't disagree what the RSO says. I don't disagree with what the law is, but the onus is on the tenant to prove that it was a service. That has not happened.
Okay. Anyone else at this time like to weigh in, comments? Anything further from legal counsel?
No, Chair.
Okay, Commissioner Montemure, you had something else?
No, I'd like to make a motion.
Okay, we have a motion.
I'd like to make a motion to adopt resolution number 2206605, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D4603.
I'll second.
All right, we have a motion and a second. Is there any further discussion on the motion? Mr. Secretary, may we have a roll call vote, please?
Commissioner Ayers,
Aye.
Commissioner Kerpies,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemure,
Aye.
Commissioner Topshin,
No.
Chair Copeland.
Aye. And the motion passes. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 or by email at rsh@weho.org. You're welcome to go back into the waiting room and watch the rest of the meeting if you would like to, and thank both of you for your participation. Appreciate it.
Madam Chair, may we take at this time a short recess?
Yes, what do we want, 5-minute break? Would that be good?
Less, that's fine, or less is fine.
Okay, let's come back in 5 minutes, please. Thank you. think we're waiting for Commissioner Montemayor.
I'm here, sorry.
Okay, no problem. Okay. We're ready to call the meeting back to order. The next item that we have is unfinished business. Proposed amendments to the rent stabilization ordinance and rent stabilization regulations. Mr. Manager, we have a report from you on this one.
Yes, thank you, Chair. Again, Jonathan Holub, I'm the Rent Stabilization Manager. Thank you, Commission. So I'm here to present this item on recommended amendments to the Rent Stabilization Ordinance and the regulations, and I'm joined by Information Coordinators Gloria Viles and Anwar Zrekat. And if there are any questions that I can't answer, they will be able to, I'm sure. I have a presentation that I'm going to pull up on my screen. Just give me one moment. Okay, I'll go through the presentation and then after, of course, I'll take any questions. I recommend that I complete the presentation because there's a lot. And if we get bogged down in a particular item, we might be here longer than you want to. Okay, so the first amendments I'm going to present are related to council-initiated items that will relate specifically to the rent stabilization ordinance. The first proposed ordinance amendment relates to a pet security deposit ban. The council directed staff to look into the issue of security deposit bans for additions to pets to a unit, or a ban on pet rent. Staff worked on this issue and determined that a pet rent ban is not appropriate. One, because rent stabilized units are already, rents are controlled, and a landlord can't just raise the rent. And for a non-rent stabilized unit, we can't control that. But what we do have authority to regulate are deposits up to a point. State law governs how deposits are handled at the outset, but the city can regulate subsequent increases to the security deposit. So the proposal is that for tenancies created after the effective date of the amendment, a landlord may not collect an additional security deposit for pets, even if not previously permitted during a tenancy. For a tenancy commencing after the effective date of the amendment, the tenant may possess one domesticated dog, cat, or bird weighing not more than 35 pounds. And this doesn't exactly track, but somewhat tracks the ability for a person who is a senior, disabled, or living with HIV/AIDS to have up to 2 pets of the size. And this will apply to most residential rentals in the city. The next item is the directive to register all units now in the city, for the most part, including non-rent stabilized properties. This amendment would require registration and re-registration of most residential properties and rental units in the city, including what we call new construction, condos, and single-family residences. New construction is construction that receives its certificate of occupancy after July 1st, 1979. In order to bring our internal systems in line with the new requirement and allow landlords time to register, staff is recommending an implementation date of January 1st, 2023. Failure to comply with this would result in an administrative citation issued to the landlord. And per council's direction, a registration fee would be imposed. And the city is currently doing a fee study to determine whether or not the current registration fee applicable to rent stabilized units would be applicable here, or whether a different registration fee would be appropriate. The next item is additional flooring types when it comes to minimum maintenance, which the commission is very familiar with. This was a direction that accompanied the last major amendments to the RSO relating to an enhancement of posting requirements, tenant habitability plans, and tenant harassment. So currently, upon tenant request, the landlord shall replace the carpet, linoleum, and/or vinyl once every 7 years. The direction came from a concern that certain flooring types that do come up occasionally in hearings are not being addressed, and the amendment would add laminate, bamboo, and cork flooring to the list of flooring types subject to the requirement. The next set of amendments are also rent stabilization ordinance amendments, but these are staff initiated. The first is a recommendation to prohibit side agreements. And this, for the most part, would be a restatement of existing law. What staff has occasionally found is landlords trying to parse out housing services that are part of the use and occupancy of the tenancy. Those are not permitted, but it's not specifically stated, and this would do so. Parking has been treated as something apart from the use and occupancy. And so side agreements have been allowed, but staff is recommending that parking going forward be treated as the other housing services. One reason for this is that as folks age in place and are on a fixed income and they need parking, if the landlord were to have a side agreement with the tenant, then they might wind up having to be displaced if they couldn't keep their car because the parking rent is too high. The next proposed amendment is a prohibition of division of master metered costs. This is another item that is actually a declaration of existing law, but should be specifically stated because we do see occasionally landlords using these what are called ratio utility billing or RUB systems. They're unregulated, privately managed systems that use a formula for dividing utility services such as water. It results effectively in a variable monthly rental amount for a landlord provided housing service. Another item that staff would recommend moving on is registration of on-site property managers. As you know, properties with 16 or more units in which the owner does not live on the premises require an on-site property manager who keeps regular business hours. Administrative hearings and tenant complaints indicate that not all non-exempt properties in the city are compliant with this requirement. The amendment would require registration of on-site manager information and provide for issuance of an administrative citation when the requirements are not met. This doesn't preclude the issuance of a rent decrease, but it adds an enhanced enforcement component. This is more of a technical amendment to the prohibition on parking removal. Currently, section 17.52.120 prohibits a landlord from removing a parking space housing service once provided to the tenant without the tenant's express agreement. And if a landlord violates that by taking away the space without getting an agreement on that, then civil and criminal penalties may apply. This amendment clarifies that no civil or criminal penalties will follow from removal of a space due to government order or to establish an ADU is allowed under state and local law. Of course, if you know this as it exists, there would be no prosecution or action taken when the landlord is trying to get in compliance with something else. But in order to clarify and to make sure that there's no conflict there, we're recommending that this amendment be enacted. And of course, the tenant can still pursue a rent decrease even if other enforcement action can't be taken. These next set are the regulation amendments that are being proposed. The first one you're very familiar with. It's the regulation amendments dealing with valuation of housing services in rent decrease cases. And this is based on the very hard work of our Commission's ad hoc committee that reported back to you a couple months ago. It would integrate updated values into the regulations, including provision for annual adjustment beginning effective September 2023. It specifies that the hearing examiner and commission shall consider factors including quality of life, the MAR, and guidelines when making valuation determinations. It directs consideration of square footage and the actual cost of the lost housing service when appropriate. And there would be no mitigation of value when removal is due to complying with code or insurance requirements. And these are the directions that came from the discussion following the report from the ad hoc committee. The next proposed regulation amendment is to allow staff to make administrative terminations of disputed re-registration information. This became more of an issue when the division transitioned to online re-registration. We still process paper, but more and more so we are processing through an online re-registration process. And there's a back and forth verification process. Usually it works fine, but occasionally there's a disagreement on what either the initial rent is or the housing services are. And based on the information that's provided, staff can in fact usually make a determination on what the correct MAR at the outset of the tenancy is. Right now, it is directed straight to an administrative hearing, which is quite time consuming and costly and not necessary. So staff is recommending that change. And just like any other administrative determination in the regulations, it's appealable to the director if someone disagrees. And it doesn't preclude the filing of a MAR overcharge application after the fact by a tenant or a landlord if they need to do that. The next item is a integration of rent concessions in calculating the initial base rent. The commission saw a case related to this issue recently, and this regulation amendment somewhat integrates the determination that was made in that case. The concessions often result in an actual rent that is lower than the rent asserted in the lease agreement or the re-registration form. To remain compliant with the requirements of the RSO, concessions or, quote, free rent must be considered. The amendment looks to the actual amount demanded, received, or collected during the initial term and the resulting monthly amount. The next item is a presumption regarding move-in dates for awarding common area decreases. Currently, landlords are directed to provide a rent roll with move-in dates when an application for a common area rent decrease is filed. That's conveyed to them in the documentation provided at the outset of the hearing, but it's not codified. So this would just codify that requirement so it's clear that it's a requirement, and that if a landlord does not provide that rent roll, then then all units would be subject to the rent decrease if it's a common area loss of housing service. Effective dates for rent decreases and restoration of rent. The current, as you know, the current decrease goes in effect or restoration of rent if it's a compliance termination is effective on the first rental due date following the issuance of the decision. This proposed amendment would make the effective date for rent decreases the first rental due date following the acceptance of the application as complete. So, for example, if the application is deemed complete on March 15th, and the tenant ultimately gets a rent decrease, it would be effective April the 1st, as opposed to the next rental due date after the issuance of the decision. Currently, compliance terminations are if they are uncontested or they're simple to determine, then they are issued 10 days after the time to object, and the rent is restored immediately on the next rental date. The issue that's come up is that when we've had hearings, when they're necessary, the decision can sometimes take a while to issue, and it's inequitable to and inconsistent really with the existing law to have that restoration be delayed. So it would be as though if the restoration were granted through a hearing, the restoration would occur as though it was an uncontested compliance determination. And the final amendment is just a technical amendment related to the issuance of subpoenas. A while back, the municipal code was amended to be consistent with state law. which limits the issuance of subpoenas, the authority to issue subpoenas with the city council. And so this amendment would simply make sure that the regulations reflect that reality. And that is all I have, and I am available for questions.
Okay, questions from commissioners for Mr. Holub? Commissioner Maggio.
Can you hear me? I'm hearing an echo.
We can hear you.
Okay. Jonathan, first question on pet rental. Obviously, if the tenant no longer has the pet, then they no longer pay the rent, right? It's based on a month to month. Would that be correct?
If you're talking about rent stabilized unit, the rent is what the rent is. If the tenant gets rid of a pet, then the rent won't change. The only situation where that could be different is there is a process for changing housing services and changing the rent along with that, but that's a formal process that has to be done through the division. So in the scenario that you just described, let's say at some point in the tenancy, the tenant wanted to get a pet and the parties agreed that that would be an additional housing service, and the parties agreed to X amount of dollars to be the new rent. They could go through the formal process. I've never seen it with a pet, but it's possible. I've seen it more with items like parking and other housing services. And then if the tenant got rid of that pet, they could apply for a rent reduction for the amount that the rent was raised. But generally speaking, what actually happens in practice is either there's a pet in place and the rent is the rent. And if the tenant decides they don't want a pet anymore, then the rent continues to be what the rent is. I've never seen a situation, maybe some of the commissioners here have been here longer, have seen a situation where a landlord attempted to remove that as a housing service. I've never seen a case like that, but generally speaking, what would happen is that if the tenant got rid of their pet, then the rent would be what the rent is. I'm just talking about rent stabilized units.
My second question is in regard to valuations. An amendment to regulate specifically set forth that removal of a housing service due to the landlord's need to make the property code compliant or comply with insurance requirements should not impact the valuation of the loss of a housing service. I think I'm a little bothered by that because it seems then the owner is penalized for something that he must conform to under the law. But yet we want to then pass that valuation on to the tenant, even though the owner is complied or is forced to comply, not only with the specific codes, but with insurance requirements as well.
Well, that recommendation is strictly from the discussions that the commission and the ad hoc committee had previously. Obviously, a different recommendation can be made at this point if the commission isn't comfortable with that, but staff's recommendation is simply based on what was previously discussed, at least my understanding of it.
Questions for Mr. Holub? Commissioner Kerpes and then Commissioner Topchin.
Yeah, I have a couple questions. I'll wait to come back to the issue of the valuation of when a service is removed based upon a court order, government requirement, or insurance reason, because I think we need to have more discussion about that. But if we can go back to this slide, maybe about the prohibited side agreements. Is it possible to pull that one back up on the screen?
Sure. Oops, sorry. There we go.
Yeah. So I have some problems with the side agreements on parking for a couple of different reasons. The proposed amendment would specify or specifically prohibit the use of side agreements on on-site, off-site parking is the effective date of the amendment. First of all, I live in an apartment that I chose when I came to look at it. It was a good price. It was cheaper than the prices I had seen at the time for other apartments similar to the size. And when I got here, I asked for what the rental price was, again, to confirm what I had read on the ad or whatever. And they offered it to me for, I think it was like $13.99 if I didn't want or with parking, and $12.99 without parking. And I took it without parking. I mean, I don't need a parking spot. But at times over the 10 years I've lived here, as spots opened up, I never actually had to change my mind and get one. But it would have been, there were times when I thought about it, that it might be of value to me to, okay, I'm going to start renting a spot for $100 a month. Now it's worth it to me, whereas before it wasn't. And I think that I would hate to lose that option for landlords. I know that it seems like we are doing this to help resolve issues when problems come up. Is that the primary reason why we're doing it? Would you say?
Not necessarily. And I'd just like to address the scenario that you presented. This wouldn't necessarily prohibit anyone from adding parking, or let's take this, your specific situation. It certainly wouldn't prohibit the agreement that you made. You could negotiate not to have parking at the outset of your tenancy, nor would it prohibit you from renegotiating to add parking and using the system that I just described previously regarding when I was talking about pets, to use the formal process through the division's auspices of agreeing to the addition of parking as a housing service and having a rent increase stipulated to based on that added housing service. What it would prohibit is the ability of the landlord to then later say, because if it's then done as a side agreement, the landlord can treat it as a separate rental. And it's more than just trying to resolve a problem that comes up. It's the issue of making sure that the goal of allowing people to age in place is not jeopardized. Because if you've got fixed income individuals who have mobility issues and need their car right there on the lot at the property, if they've done a side agreement and the landlord decides, well, now parking isn't $100 anymore, it's $500 now a month. There are going to be people who might not be able to stay in that unit because they can't afford that parking, but they need parking on site. So it's not just to stabilize rents. You know, when we see a problem come up and someone comes to us and says, I have a side agreement, it's to further a policy objective of the cities. So that's, you know, what the goal is. And I don't think anyone's precluded. I think, you know, I think there might be a suggestion that this is somehow precluding subsequent agreements or changes of mind about having parking. Let's say you want to not have a car anymore. You have one, you don't want a car anymore. You agreed to a car at the outset of a parking space at the outset of the tenancy, and you want to get rid of it. And you can go to your landlord and say, well, let's negotiate a rent reduction, and you can give that space to somebody else. That's completely allowable as well, even with this proposed amendment going into effect. But does that answer the question?
It does. I don't agree. So first of all, no one knows that you can do that. Hardly anyone knows you can do that. Second of all, the advantage to me not having it as part of my rent is that it doesn't go up unless I agree that it goes up. I have a lease, I could rent it for, it's a side agreement, side lease, it's for whatever length of term, for whatever rate that I agree on. Whereas if it's part of my apartment, it's going to go up along with my apartment every month or every year. It may only be 3%, 2%, but it's going to go up. And it's just going to be baked into my rent. So that's the first thing. In regards to the forwarding the city's goals, I don't quite understand that argument, because the city's goals should be to reduce the dependence on vehicles. And I know that it's not as substantial of an issue when it comes to already existing buildings, but in new buildings, it's very clear we do not want to have minimum parking requirements if we want to achieve our environmental goals. I do think it is, I can only speak from my personal experience. I know that that's not how you set city policy, but it's the basis for my opposition to this, is that I don't own a car right now. And there are some days that I really, really want a car. But knowing that purchasing that car and driving back and forth to and from work, that makes it real easy. But then when I start to think about all the other things, the parking I have to pay for at work, now I have to pay, in my situation, $100 a month I have to pay for parking here in my building. Those are things that prevent me, if I'm on the edge and trying to figure out, do I need a car or not a car? Those are the things that keep me on the side of not relying on a vehicle. So I don't think that it furthers the city's goals, because in the case where a senior citizen who has a side agreement, I mean, the side agreements, they can be good side agreements, they can be bad side agreements. You set the terms with your landlord or whoever you're entering those into. So I think that while some people can be taken advantage of that and might find themselves in a situation where they didn't agree to something that they didn't think long-term in their side agreement, I still don't think that is the reason for why we should eliminate them. But that's my opinion on that one.
Just one point on that, just to clarify, this does not apply to new construction. This only applies to, yeah.
No, I understand. I was just saying that clearly this would have, I think we would all agree it would have a different impact on new development, but I still think it does have some impact on these older developments that fall under the rent stabilization ordinance. On the next slide, I believe it was the administrative hearings. Could we see the next slide? Is that possible? Sorry.
Just one sec. What was the topic?
Well, I have administration hearings, but that's just my writing maybe. It was the next slide after the prohibition of the side agreements. It may have been the one that you were just originally on when you asked. So the one right after prohibition.
Prohibition of master metered.
Yeah.
The next one. Okay.
This one, I thought about this a lot during the first drought we had. The drought we had a couple of years ago and got over. We set the state sets guidelines and fines and water usage and all that stuff. And unfortunately, in a rent controlled apartment, all that is my actions and my fellow neighbors' actions are a burden on the landlord. We all control how much water and electricity and all that stuff we use. Well, in this case, electricity wouldn't apply, but in water we use. But yet there are no ramifications of the amount of water I use. I could run water all day long and my landlord would see the bill. I have no idea what the bill is. And I just feel that most of our buildings in West Hollywood, I'm not suggesting a change to at all. You know, if they don't have the technology to divide up the use of the resource or the water, then that's fine. The landlord that's a service they offer. But when the technology exists and new tenancies begin, it just seems to me to make sense that the tenant should be responsible for the cost of the water that they use. And I just hate to see, I mean, this really is a thing that does cause burden on a landlord, especially during those times when we have in droughts. So that's my concern there on that one. But I am in full agreement that if they cannot have a reliable, trusted, system way of breaking it up, not dividing it up as in, equal share, but to actually measure each unit's use, I hope that we could allow for that in the future for new tenancies, but not preclude it. On the ADU issue, I didn't quite understand the parking, how that had to do with the parking. Was that, or I guess the whole issue of why are we decriminalizing the removal of a parking space again?
Well, that did arise from specific instances where, there's a right to create an ADU under state law now, as you know. So in certain circumstances, parking might be eliminated because of that conflicting right. And it just conflicts with what the state has mandated to have something in there that says that somebody can be criminally prosecuted for removing a parking space for doing something that they are allowed to do under state law. So that's the reason for that change.
And this is the city attorney agrees that would be a conflict of. I wasn't aware that you had to. You
don't have to remove parking. It's just that there's been circumstances where to make the ADU compliant with building and safety codes, some part of the rest of the property might have to be altered, and that has included parking.
And we couldn't just make an exception for that. And I think you listed 2 or 3 other reasons why we couldn't just make an exception for that for the criminal aspect. So
I'm not sure what you mean.
I guess what I'm saying is, why can't we just take those exceptions, put them into the current law, and say it's still a criminal act to remove parking unless it's for one of these reasons?
That's what this would do. That's what this would do.
Doesn't it also decriminalize parking, removal of parking?
No, just in circumstances where someone is doing something they have a right to do, like specifically an ADU. That's why it refers directly to the provision of the code that codifies the state mandate to allow for these ADUs. So it's doing what you say.
It would so it would still be in any other situation. If I have a parking spot when I move into my apartment, it's part of my agreement. If they remove it, it's a criminal act. In addition to, I can apply for a decrease in services.
Right. If the landlord has taken it away for no lawful reason, then I should say for not one of these exceptions that we're setting forth, then yeah, the landlord could still be prosecuted under the law. Okay,
I misunderstood. And then, okay, I'm in agreement with that. That one then, and then so that brings me back to the conversations that we had before about the value of the removed service, whatever it may be, due to a reason beyond the landlord's control. It was either a code violation or safety issue, all that. I thought what we agreed, and maybe this is just wishful thinking, because there was quite a discussion about it at that time, but I thought what we had recommended was that we wanted to make clear that the fact that it was removed for a code enforcement reason was not a factor in determining whether a it was irrelevant to whether the question of whether a housing service was removed or not. It definitely could be argued that, and that we would remove that. So no hearing examiner would say, oh, well, that was removed because of XYZ. So therefore that doesn't count as a removal of a housing service. We wanted to clarify and make sure that that didn't happen anymore. But we didn't want to go, and the others can correct me if I'm wrong, but we didn't want to go so far as to say that the hearing examiner couldn't take that into consideration in terms of the value of what the service was. And I think Allison years ago explained to me why this would be relevant in that, let's say, for example, we had a parking spot that was illegal because pipes and all this other stuff was above the vehicle, and it just wasn't safe that way. And so we removed that for code reasons. That person would still lose their ability to park there, but when comparing it in value to the parking spot that's perfectly fine right next to it, and in this crappy, one that has pipes hanging all over it, it's going to have a different value. You wouldn't be able to sell it for the same price. So the hearing examiner, leave it up to the hearing examiner, allow them to weigh all the evidence and figure out what the value is. We haven't had a problem with that part in the past. We've only had a problem with the hearing examiner just basically saying, oh, that's not a service because it was removed. We've always, so that's where I'm coming from on that. But I just thought it didn't reflect what we had ultimately decided.
The commission will have to clarify that for me, because my understanding was what we have here, and if I'm wrong, then we'll correct it, obviously.
Maybe others have recollections different than mine.
Commissioner Topsy.
Yeah, Madam Chair, if I may, I just want to make some comment regarding this particular issue, but I have some other questions later if you allow me.
Yes.
When Commissioner Kirkus obviously finishes his thoughts. Regarding this particular issue, so if Commissioner Kirkus, if you remember, I understand what you're saying, but if you remember the reason why we wanted to have something that would say removal of this service due to the order from the city or some other reasons should not change the values, because previously the examiners would say, okay, so the landlord has the insurance order or the city's inspector's order, so therefore I'm not going to apply that full range of the parking reduction, like $100 per month. So I'm going to do a nominal $1. And we couldn't do anything about it because, as we know, we cannot substitute our judgment for the examiner's judgment bias, because that's our hands would be tied in that position. If the examiner makes a decision that the value is $1, and because that service was unapproved, and then the commission's hands would be tied. We can't say, oh no, the value is not $1, the value is $100. So that's the reason why we wanted to have a language specifically here in our rules and regulations that would say that whether the service was provided legally or illegally should not have any effect. So it's basically for the examiner to understand that it doesn't matter the service legal or illegal. He should use the guidelines as is. So, and not to put his own value, because what you're suggesting is that basically going back to the same thing. Yes, there was a reduction in rent, but it was $1. So that's what we want to avoid here. Thank you, Madam Chair.
Thank you. Commissioner Kirkus, did you want to continue with?
Well, not continue, but just on this specific issue. And
Okay.
I kind of feel like we're having the same conversation that we had, because I think it was really me and Commissioner Topchian who probably disagreed, or we were trying to come together, but we just couldn't kind of mesh our thoughts on this one previously. But what I tried to explain last time, and I'll try to explain it more clearly this time, is there's two questions. There's the question, is it a housing service? Is it a loss of housing service? And we have historically seen several times over and over and over that the hearing examiner say that it was not a loss of a housing service because of X, Y, Z, whatever, the insurance, whatever it might be, code enforcement. but the commission has always come back, at least that I recall in the cases that I was participating in, the commission has always come back and said, no, that's incorrect. And then we placed a value on it based upon whatever value we come up with. But I don't recall, so that's the first question. Does the housing service exist and was it taken away? And then the other question is, if that's a yes, then the separate question is, what is the value of that housing service? And I'm just recommending that we not limit, the hearing examiner has not gone crazy on going outside the bounds in terms of once they get to that question, or once they get to that space where they're figuring out what the value is, we have sometimes corrected them, but that has not been really the issue. Like the issue, the root issue really is them saying, oh, it's not a housing issue or it's not a housing service because of these other reasons. So I would just, that's all I'm recommending is like, we don't need to tie the hands of the hearing examiner. We can still make it very clear that it is a housing service, that or it should be irrelevant whether it's a housing service taken away because of that reason, that shouldn't play a role in deciding whether it was a housing service. I want to keep saying that word over and over. Thank you.
Thank you. I have a question real quick for Mr. Holub. Are we trying to add some specificity in this as far as, let's say, for example, you have a back walkway that you've been able to use and it's all of a sudden it's cracked and it's leaking and it's not safe anymore and code compliance says or building safety is out of code, can't use it anymore, and the landlord blocks it off and takes it away. I mean, are we trying to say that since it's not code compliant, it's not the landlord's fault? Or are we trying to say that that should not be a consideration because he should have kept it code compliant in the first place?
Well,
so the tenant should not be punished for that.
Right. Well, I understand what understand exactly what Commissioner Kirby is saying. I didn't realize that was the direction to specify that the hearing examiner, to answer your question, Chair Copeland, the housing service is a housing service. So whether it was removed because it was not code compliant or not, doesn't matter.
Right.
I don't, it sounds like there've been cases where hearing examiners have said, well, it was a code violation, therefore I'm not going to evaluate at all. I wasn't aware of that, and I apologize, Commissioner Kirby, if that's what you were discussing last time we met. I didn't get the difference at that time, but I understand now. So we can add specificity just to make clear that you shouldn't be, to the hearing examiner, you shouldn't be discounting it as a housing service simply because it has been removed because it needs to get code compliance or insurance compliant. If the commission wants to give that direction, and for when I finalize the resolution for council to add that, that's something I'm sure I can integrate. That leaves the outstanding issue that I'm still not wholly clear on based on this discussion as to whether or not the commission wants the hearing examiner to then, when actually deciding what the valuation is going to be, to take the fact that it was a code violation to begin with into consideration. That you're shaking your head no. So I think that what we have here is what the commission wants, but with the addition of clarifying language that says, don't discount this as a housing service simply because the landlord was coming into compliance with the law or with their insurance provider. Is that accurate?
So we're not saying that they must take it into consideration, but we're not precluding them from. I mean, we don't know what situations may arise in the future. And we haven't seen problems with, I mean, my recollection is that we have not seen problems on that aspect of it. It's always been primarily based on the original, like if we make clear to the hearing examiner that they can't take that into consideration when deciding if it was a hearing or a service or not, then fine, that's out of their minds now. It's clearly a housing service that was lost. So now they're just looking at the value, and they should be able to look at, like in your case, Chair Copeland, about the condition of the pathway. Let's say the condition was always really bad of the pathway when the person moved in, but then 6 months later, code enforcement sees it and says, that's horrible, we got to shut that down. And so the landlord cuts it off. So the tenant, the hearing examiner should be able to take into consideration that it was not a pristine pathway, access way. It was not a beautifully marked normal sidewalk. It didn't, those are the things I'm thinking. I'm saying let the hearing examiner be free to do as they do now and take all factors into consideration when deciding the value of whatever service it was that was lost.
May I just interject there? I think that it's possible that the regulations as proposed would, my opinion is that it would still allow for that. It's just that now the analysis would have to be, you can't reduce it because it was determined by code compliance to be a code violation. You can't reduce the valuation. But the other factors that you're talking about, the condition, how often it was used, what value a tenant moving into the building would put on it, the level of convenience. These factors are all still open for consideration. So I just want to make sure that I'm clear on doing what the commission is asking. So does that sound like what's in place would get to the goal that you want to get to, or is there a disagreement over the issue of considering the fact that this is a code violation means that the hearing examiner should have the authority to say, I'm going to reduce the value because it was a code violation? Is that the disagreement, or am I misunderstanding?
I don't think it would be. I think the code violation would be evidence of unsafe, or could be. I mean, I don't know if a hearing examiner would actually say, or should say, because it's a code violation, it is now reduced. I'm saying that because it's a code violation, the hearing examiner might find a certain situation and say, like, well, yeah, clearly that's a code violation, and it's unhealthy. It's not safe to have had that service. It wasn't a safe service when you had it, so it's not comparable to a regular service in terms of maybe the walkway on the other side of the house. To use the example that like Chair Copeland was using, it's like the walkway on one side of the house would be valued at a higher value because it's safe, but this one's been closed off would be lower value because it's unsafe anyway. So it's not necessarily putting in the argument that because it's a code enforcement issue, it's valued less, but the factors that led to it being a code violation might cause it to be less. I just don't understand why we're changing the policy. I'm not restricting, and I don't want to confine them. Why don't we leave it how it is on that part of it? And only, we definitely all, I think, agree on the first part that it shouldn't be considered not a housing service just because it's a code violation. I think we for sure can agree on that part. I just don't understand why we have to narrow it down, limit the.
I think you complicate things here. I'm sorry, Madam Chair. Commissioner Kirkus. So the examples that you brought up there, obviously these examples could happen, but if you remember, you've been on the commission for a number of years, so for a long time. If you remember those type of cases we had, they related to removal of the patio or a kind of a balcony or a rooftop patio. So these are type of services that you can actually put a really high value on it. And I remember specifically, we had a case years ago that when the patio was cited by the code enforcement and the insurance said you have to remove it, the landlord's private insurance. So the examiner looked into that and said, yeah, it's a housing service. But because the city order, the value is going to be $1, and we're talking about big patio. Yes, it was illegally created, but when the tenant moved in, the value for that patio was incorporated into the rent, and the rent was higher than the comparable unit next door in the same building. All right. So if because the tenant has this private patio, the rent was $3,000. The same unit next door, hypothetically speaking, was $2,500. So tenant pays $500 extra to have a patio. So now, in order for the examiner not to treat this any way different from any other patios in the city, legal patios that were removed or prevented the tenant for use, this language is needed. So then the examiner's message will be, Mr. Examiner or Mrs. Examiner, this is a service, and this service, although there is because the examiner may get confused. I have the city's inspector's order saying this gotta go. This is not safe for the tenant to use it. So the examiner may think old school way is that, okay, it's a service, but it's a value $1. So I'm not gonna penalize the landlord. But then by putting a value $1 or $5, you're penalizing the tenant who continues to pay that $3,000 rent by not having that service. So that's why we thought, and the committee and ad hoc committee and the commissioners, and we had the discussion. We wanted to have something. That language may change, obviously, if the commission wants and the manager wants to change it. But I think the message should be for the examiners. We're not going to be in the commission maybe next year or in 2 years or 5 years from now. Whoever the future commissioners will be and the examiners, they need to understand that they cannot go back to that nominal $1 rent decrease. So that's the whole point of acknowledging this is a service. And if it's a service, just because it was not called compliance, it still has to, the examiner still has to use the valuation guidelines and treat it as any other service. It doesn't really matter because we're talking about the tenant, about the tenancy. Not about the service, whether it's legal or not legal, it's irrelevant. We're talking about the impact on the tenancy and how the tenant's rent will be impacted when this is removed. Thank you.
Anything further from other commissioners on this subject or this part of the presentation? How about comments on other parts, or Mr. Holland, would you still go ahead? Commissioner Topchian, I'm sorry, go ahead.
I just other comments, not about this. This item is, we're over on this item, Madam Chair.
Mr. Holland, do you have any thing further on this item?
I just wanted to add a clarifying point. So based on the discussion, I'm inclined to recommend keeping the language as is. I think that the sub C of the, sorry, I don't have a page number here. I'm using my own copy.
When you say as is, does that mean like in the tonight's language?
In the regulation, because the first point Commissioner Kirby's about being concerned that a hearing examiner might discount completely discount an eliminated code compliance removed housing service. The proposed language states that a reduction of rent is applicable to all substantially reduced or discontinued housing services, regardless of whether the housing service was created or established in violation of any provision of law or insurance provider requirement. So I think that sentence takes care of that issue. And then the second sentence takes care of the issue that was just discussed. The value of the housing service shall not be adjusted downward if the discontinuance or substantial reduction is attributable to bringing the property into compliance with any legal, regulatory, or insurance provider requirement. And I think that now that I'm reading it again, it captured what my understanding of what the commission agreed upon. And again, I think that the using Commissioner Topchian's example, The commission, the hearing examiner could still consider, for example, that patio was not the nicest patio compared to the neighbor's patio, or it wasn't one of the primary reasons why the tenant took possession or something like that. So I just have to, I'm beating a dead horse just because I want to make sure that I'm clear on what the commission wants, so that if we end here tonight, I'm getting a recommendation and an approval on language that is satisfactory in what you want to do.
Can you tell us what page you're reading that off of? Sorry.
Yeah, I apologize. I should be working off of the packet, but I'm working off of my own copy. Hold on just a second.
To me, Mr. Holland, once you when you read that just now, it sounds like what we discussed as the committee, and then again as the commission afterward. To me, to be sure that those two were very specific, and I mean, it sounds clear to me, but I think that's the intention that we had behind it, and the wording sounds right.
Thank you. So if you go to this item, it's attachment E. Attachment E. And for some reason, there's no page numbers on the resolution. Apologize. But it is page 1, 2. It's the 5th page of attachment E.
So it starts with 7 at the top. It starts with 7. Is that page?
Correct.
Okay.
So C is what I'm reading from, capital C.
I mean, we're done talking about it. So whatever my colleagues agree, I mean, I will vote for it, whatever we all agree on.
Okay, yeah, I don't want to be responsible for keeping you here all night, but I just wanted to make sure that I'm expressing the will of the commission when I bring this to council. But thank you. Okay, that's all I have.
Okay, Commissioner, comments or questions?
Is this the time? Yeah, I had some questions. I'm sorry, I can speak at the last. Let the other commissioners to speak. I have some questions.
Is anyone else ready to speak? Questions? No?
I don't have any questions, but I do share Commissioner Kirby's comments. I'm aligned with him when you go to council, Mr. Director.
Okay.
Thank you.
Commissioner Topchin, you had some comments?
Thank you, Madam Chair. Just wanted to, Mr. Manager, thank you very much for this, for sharing with us this report. I wanted to ask you about the on-site manager change. The real change is basically the requiring the landlord to file with the city the information about the manager, right? As I understood correctly.
Yes, that would be one of the requirements of the amendment.
What are the requirements? Now, if and I know that, and the probably commissioners who see it in the valuation guidelines, we increased we proposed the increase for the reduction of on-site manager services. I think previously it was, I don't remember the amounts, but I think it's now, it's almost close to what other jurisdictions, specifically Santa Monica, has. It's a higher value for the reduced service. And I think this is a very important service. Sometimes maybe we don't really see it as important as this can be, the elimination of on-site manager services. And we want to make sure that buildings with 16 units and plus, they have on-site managers. So posting the manager information for off-site manager or landlord's contact information is not sufficient. So I'm in full support of this. And I just wanted to ask you, Mr. Manager, if let's say there is no on-site manager and the tenant files a complaint, obviously the examiner will determine the reduction in rent. But what other remedies, what other penalties there would be for the violation for not having on-site manager? Because I understand this is not just the rent stabilization ordinance violation, but it's also a code violation. So what is the what are the penalties, if you can briefly explain?
Well, what would happen with the amendment is that the failure to provide an on-site manager in a building where it's required would subject the landlord to an administrative citation. Staff, if it passes, staff would have to make a recommendation to council about what that penalty would be. Some of the other penalties for violating the RSO, basically the first violation ranges from $250 to $1,000, depending on the violation, generally speaking. So that would be the first thing that would happen. The code currently provides that after the issuance of a first violation, a first citation, if the landlord doesn't come into compliance, one or both of the following might happen. Either they will get another citation for an increased amount based on the fee schedule, or they will be prosecuted for a misdemeanor violation of the municipal code. So that's what would happen.
Okay, so there will be a number of measures taken to get compliance. Mm-hmm. And obviously for rent decrease would apply to each and every unit in the building, right? Because it's Correct. A common area service. Okay, right. Thank you for clarifying that. So the other thing is regarding the pet rent. So the pet rent, it's a little bit confusing to me, and maybe I didn't clearly understand. We are saying that at the initial rent includes the pet rent, right? That's the idea. So, but if we're mentioning the pet rent, so then the logical question would be, how much is it? If my rent is $3,000 and I have a little dog, so how if I understand that the $3,000 includes the pet rent, then that would be the pet rent. In case there would be some consideration or a position that removal of my dog may be a housing service reduction. So my confusion was about that, why we need to state that pet rent is the part of the rent. Why don't we just don't mention pet rent? Why don't we just say no pet rent is permitted? If we can legally do so. That's one point. The other thing is pet rent versus pet fee or pet charges. So if we are saying that pet rent is incorporated into the initial rent, whatever the tenant pays, can the landlord, which is not, let's say, identified anywhere in the rental agreement, and later on, let's say the landlord says, I want you to pay $25 pet fee. That's not a security deposit. That's not a pet rent. That's a pet fee. Would that be permissible? In a rent
stabilized unit, no, because it's rent. Okay. I mean, you can call it whatever you want to call it, but it's either rent or deposit. changing the name.
So
of the
benefit of it, I see it. So it's just basically a tenant can have a dog or a cat or whatever, a pet, and there is no pet rent. So that I see the benefit. But I also am thinking in a hypothetical possible scenario. Let's say ownership changes, or the pet is no longer in the unit. These type of issues may arise. I believe maybe we can come back and we would probably consider some amendments, but to me it could be a little bit confusing to see it's like a pet rent incorporated in the initial rent. That was my thought. I don't have any recommendation, so I just wanted to share my thought. And in regards to the ROBs, the third-party utility charges. I agree with the prohibition of that. There are so many issues with the third-party utility companies. It's just unbelievable, and the fees, how they impose. There is no absolute consideration. The tenancy composition, how many bedrooms, how many people live in the units. There could be one person living in a rents 3-bedroom apartment versus 3 people live in a 1-bedroom apartment. So nobody does it. So they get the bill and they divide by number of units. It's a mess. So I totally agree with what it's been recommended here. And I understand the concern that the landlords may have. So the solution would be just to individual master meters. So change the master meter to individual meters. Do that, but don't hire a third-party utility company that will send these weird bills. So I like this and I support that. Side agreements, prohibition on that, I also in support of that, and I understand the reason why it is suggested, and I'm in total agreement with that. I think that's it. Thank you, Madam Chair, and thank you, Mr. Manager. I mean, this has been a really incredible work that you and your staff did. I think it took like, I don't know, probably a month to prepare this, to put together. It's enormous work, and I salute you guys for it, and thank you.
Thank you. Are there other commissioner questions or comments at this time? I do have a question for you, Mr. Hall, about side agreements.
Sure.
Hypothetically, if a landlord said, I'm going to charge you $150 to park, and then a couple of years later, somebody else offered them $250 down the street, they could remove that parking, or that, since it's a side agreement, if I were to come to the rent stabilization office, basically there's nothing they could do to enforce it because it's a side agreement. It's not included in the rent. Is that correct?
That would be correct.
Okay, so there would be no recourse if that's a side agreement separate, not through the city.
Right.
Okay, I know, living in a construction zone, that parking right now is almost come to blows. I get contacted about that quite a bit. The construction workers do unfortunately violate the contract and park on the streets, and then you have senior buildings who do not have permitted parking, and so it's gotten to be where people have been caught selling their visitor permits. Landlords are telling prospective tenants that the apartment does not include parking, and they are selling the spot to people who live elsewhere at a higher price. So I agree with the no side agreements, because that takes away the recourse from the tenant if they lose their spot. And as you pointed out, as we age, we do have an aging population that isn't going to be scootering or, taking the buses, and they do need to keep their cars. So I would like to see that remain part of the unit and not a side agreement. So I do agree with that. And also I would like to echo, thank you so much to you and to all the staff for all the work that went into this, and to very carefully and thoroughly going over the ordinance and seeing where we needed to improve, tighten up, and update. And it means a lot of work has gone into it, but it's very encouraging to see it. So thank you for that.
Thank you.
So there's no more questions on the presentation at this time.
I do have some questions about clarifying just 2 issues.
Okay. Commissioner Turpin?
Maybe I misunderstood. So is the prohibition only on rubs and other, as Commissioner Topshian just said, would our ordinance still allow for individual meters or individual the technology that actually separates out individual units to do separate billing? That would go directly to the tenants, or does it also preclude or prohibit
It
that?
has to be a utility managed, separately billed device.
Okay.
The reason being that it's
I'm
still a master. Yeah. Okay. That's the answer.
So
Yeah.
I was confused. So yes, I agree with Commissioner Topshian about rubs, the ratio thing, that we should not allow that, but we should, if somebody wanted to pay the expense to have their building done in a way that had separate meters and it was done by the utility company, that's what I would like to see still protected.
That would be fine.
Allow them to do. Okay. Then I'm fine with that one as well. And a question on the parking. Does the city not have the authority? I know this kind of goes a little bit beyond what the rent stabilization ordinance is and, maybe our purview, but does the city have the authority to regulate site agreements so that, like a rent control, like that site agreement, if they both have to agree to end the agreement?
If there's a side agreement, it exists. I'm not sure I understand the question. You mean if there's an existing side agreement, or just in general?
Yeah, the concern is on the parking. Like if we have a side agreement, the parking, it could end. The landlord could find a better deal or make more. And I understand that, and that would hurt people on fixed incomes, and they wouldn't be able to be competitive on that. But so my question is, would the city have the authority to clearly state about side agreements related to parking spots? For one, I don't know if the city allows right now, if it's legal to sell your parking spot to somebody else. I don't know if that's even allowed. Some cities don't allow that. So my question would be, can we just put limits on, if that's the concern, put the limits on what that side agreement can and cannot do? Like both parties must agree to end it. Something like that.
I don't know the answer to that right off the top of my head.
I would rather see something like that. I guess that's maybe the recommendation that.
Yeah. Well, what I don't think could be done is it's more challenging to enforce private agreements that don't have anything to do with the rent. I mean, that much I can say. I'm trying to think of something analogous where I could say yes or no, but I haven't thought about the issue enough to give you a definitive answer right now.
So maybe would the commission be okay with, we said that we understand the concern about side agreements, and if possible, our preference would be that we do not tie parking with the unit. I had to say it in reverse. I mean, if we send it to council in that way, then the city attorney can give them an answer about whether that's even an option, or that they're limited to either allowing side agreements or not. I just hate the fact that we are continuing this subsidization and of parking for people. That's all I have.
Thank you. Any other commissioners want to weigh in on that, or anything else as far as side agreements for things such as parking? I think it's because of the question that we cannot enforce increases or having it taken away. It just becomes very complicated, and there is a shortage of parking, obviously. So I am against side agreements. I'm actually for the change in that, but I'd like to hear what the other commissioners have to say on that one. Other than that, I think I'm in agreement with everything else that's in the changes that were proposed. That's for me. Commissioner Ayers?
I'm in agreement with the side changes recommendation or the side deals. And I'm in agreement with the recommendations for the city to the city council.
Okay. Mr. Holub, are you going to need just discussion from us, or are we going to need a vote on this for you? Do you need a vote on us? Or just
Yes, I would need a vote on both recommendations. Since it sounds like the consensus is to forward them as is, and of course, I'll indicate in the staff report some of the concerns that were raised by individual commissioners. And that provided there are no specific amendments to what we're recommending, that's how I'll proceed. But
do you want
I think the best way
vote or a roll call vote official?
I think that, if someone wants to make a motion to advance these, we can see what happens.
Okay.
I'll make a motion that the Rent Stabilization Commission recommend to the city council the amendments we discussed here to the rent stabilization ordinance and the rent stabilization regulations.
Okay. Do we have a second?
Second.
Okay, we have a motion and a second. Is there any other discussion on the motion before we?
This is a question about the motion. Is that incorporating what we've talked about tonight? Even though I obviously have been the minority, will my concerns still be included in the report? Is that what you're?
That's what I was saying, that obviously I'll mention those in the staff report to council, that, commissioners raised certain concerns and what you raised would be addressed.
Thank you.
Okay, is there any further discussion on the motion? Okay, may we have a roll call vote, please?
Commissioner Ayers,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Chair Copeland.
Aye. And the motion passes. And thank you again, Mr. Holub and staff, for all the hard work on that. A lot of work went into that. Do we have any items from staff at this time?
Just wanted to also thank my staff for all their hard work. Amor and Gloria here tonight, thank them for their work, and for the entire rent stabilization staff for assisting me on this item, and for the commission for enduring a lot of material. Thank you.
Thank you. It's much appreciated. Do we have any public comments at this time, Mr. Secretary?
There is someone in the waiting room. Not sure who they are. I'll admit them now.
Okay. We do have a public speaker.
Caller, I'm asking you to unmute.
Okay.
If you can hear me, it's, oh, sorry, go ahead.
Yeah. Just wanted to read this, that for public comment, the Rent Stabilization Commission values your comments. However, pursuant to the Brown Act, the Rent Stabilization Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. And this public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the Rent Stabilization Commission. Thank you.
Caller, if you can hear me, you can press *6 to unmute yourself.
Good evening, everyone. I'll make this quick. Hello?
Hello, yes. Could you state your name and your city of residence, please?
Yes, my name's Roxanne. I grew up in West Hollywood, and I relocated back on the street I grew up on, which is North Clark Street. I just wanted to thank you all for forwarding of getting rid of rubs. I think it's very unfair to the tenants, and I understand meters would be much better, more exact. I also wanted to, if I can, just put it out there to allow 100% disabled veterans to have 2 pets. AIDS, people with AIDS possibly could have 2 pets. Let's see. I am a lower level tenant along with a few of my friends, and we were speaking about how 2nd floors and above, probably since you were mentioning flooring earlier, should have more of a sound absorbing floors for us lower tenants. So possibly the 2nd floors and up, maybe have carpet instead of hardwood floors. No, that's a big ask. And I also want to thank you for moving forward the landlords not charging for parking. But also another thing I wanted to mention, I'm sorry, I know it's late, is me and a few of my friends have been, we feel victims of paying landlords for units we've been interested in, paying $30, $40 for application fees when the unit's already been rented. So we feel it's a for-profit for the landlord, and the landlord should be far more transparent when it comes to charging for application fees. I think that's all I have to say, and I want to thank you so much for all your hard work. I'm really proud. Thank you so much.
Thank you for your comments. Appreciate it. Appreciate your participation. Is there anything else from
No, I'm good.
staff?
Thank you so much.
Thank you. Appreciate it.
All right. Sorry.
Any other items from staff or commissioners at this time? Commissioner Kerpes?
I'm sorry. Well, that smile. I just also wanted to say thank you to the staff. I've said it before. I am just in awe about how many changes and work you guys have really done on the ordinance, and thinking outside the box on these different issues, and I really appreciate it. I feel like it's a long time coming, and so I really appreciate it, and thank you for all your hard work. And I want to just thank the caller, Ms. Roxanne, for staying with us this late tonight, and giving us your feedback. I believe if you can contact the Housing Rent Stabilization Department, but I believe that it is illegal for people to accept background checks or the registration fees if the apartment is rented. That's kind of hard to prove, but if that's happening to you, please report that to the city. But again, thank you for your participation this evening.
Thank you. Commissioner Topchin, you had your hand raised?
Yes, Madam Chair, very quickly. The speaker brought up that issue about the noise. If the that's upstairs unit, they're replacing the carpet, putting the laminate or a hardwood floor, that is a legit kind of a concern for a lot of people everywhere, and in West Hollywood also. I wonder if there is, and that maybe staff can look into that and maybe respond to the tenants' concerns, if there is a requirement per code to make sure that the licensed contractor is doing this replacement of the carpet to laminate or hardwood floor, or there could be an extra, I don't know, layer of whatever is added to see if there could be something the code can provide some sort of a answer to that concern. I think that's a legit concern. And once again, I want to thank staff for doing this. This is years of work that all this issue's been there for many years, and with current leadership of the department, finally, we have this before us, and it will be before the city council. This is enormous. It's a huge work that everybody conducted under Manager Hollop's leadership and others. And thank you for that once again. Thank you, Madam Chair.
Thank you. Anything further from commissioners or staff? Commissioner Ayers, yes.
Yeah, quickly, I was just checking the state's housing website for Housing is Key, and I noticed that they do have a statement saying that eligible renters continue to have special eviction protections under state law through March of 2022. Now, I understand LA County still has the protections through the end of this month, January. So I would just love to hear at our next meeting an update from the city staff on where the county is with that and whether the state ordinance supersedes the dates for the county, and how West Hollywood falls under all of these ordinances. Thank you.
Thank you. Mr. Holub, did you have a comment on that?
Just that, yeah, I think undoubtedly we'll be reporting back on developments at the next meeting on where the moratorium stands or if there's been any state level action.
Okay, great. Anyone else have anything further? No? Okay. Then we will adjourn to the next meeting of the Rent Stabilization Commission, which will be held at 7 p.m. on Thursday, January the 27th, 2022. Via teleconference. And thank all of you for your patience tonight. And it's been a long night, but very productive, and very happy about the changes that are coming, and appreciate all of you and your input and your patience. And take care, and we'll see you soon. Good night.
Great job. Bye.
Great job,
Well,
Chair
well,
Coughlin.
they-
Thank you.
They pulled it on me at the last minute, so.
Yes,
You did great.
considering that you did a
April
great job.
Fools. Thank you. Good night.
Thank you. Good night.